between a man and woman, and marriage is a bond of enduring. The Supreme Court has marriage men and women.
It includes the power to be considered by the both union and state government. The state shall make provisions of any existing law, whether amending or repealing any provisions which falls within the subjects of such entry by the state. The power conferred in List 3, Entry 1 are subjected to concurrent list jurisdiction. Hence, the both union and state can enact law regarding entries. Article 15, subclause 3 of Constitution of Imarda states that nothing in Article 15 shall prevent the state from making any special provisions for women and children. Special provisions for women and children are permissible, thus there is no discrimination on grounds of sex under Article 15. The Supreme Court held that the provisions relating to women and children did not violate or offend any provision, so that the repeal of marital exception from Imarda Penal Code is constitutionally valid. In the case of Shiba versus Union of India, the Supreme Court held that the promise made before the election upon achieving power.
The state of Gujarat. Supreme Court held that marital relationship means the legally protected marital interest of spouses to one another, which obligation to another like companionship.
Given by such promise, then the government will be held responsible in instant. Much obliged, Master.
You want to answer the second issue affirmatively? Positively?
Yes, Your Lordship. Much obliged, Master.
You said it is constitutionally valid.
But yes, Your Lordship. Then the government will held responsible in instant with the particular cases the government may promise an obligation to be fulfilled. In the case of Modilal versus Government of Uttar Pradesh, the Supreme Court held that the provisions made for women and women's protection is not at all violate the Constitution as the Article 15 subclause 3 of the Constitution of Imarda. The discrimination of adultery has put to light to the fact that wives should not be considered as husband's property. It leads to the conclusion that women were once subjected to prevent herself from experiencing autonomy over her body. The right to exercise autonomy over her body has been guaranteed by the discriminalization of adultery. According to the fact sheet, para 11, it is stated that Kartik has forced against Abhinaya's will and continued to engage in sexual activity with her. On second instance, para 19 states that Sunil has also forced him against Kriya, which led to injuries in her body. From both instances, we could conclude the women's body autonomy is being violated and no importance given to the consent of women only because they are under the legislation.
It leads to public data because the government want to implement any of the manifesto promise means that directly affecting the public. So, if at all it is made last to the public, then the policy may be challenged to the people, and the nonsense validity will be perceived. So, they keep on giving promise for the work-life balance. So, it is nothing but a work-life balance. So, they are giving, by way of the promise, they are going to give lot of loss to the public. So, what do you say about this?
Much obliged, Lordship. As men, women are treated as equally, and if there is any violation or if there is harm to women, the government is responsible for such harm and causes, Your Lordship, and government is responsible to enact any such laws to protect women or men both equally, Your Lordship. May I continue, Your Lordship? Much obliged, Your Lordship. That is the reason why the election manifesto focuses mainly on criminalization marital rape, as the state has greatest responsibility of protecting people from the explicitly does not comes under the purview of Section 375 of IPC. My contention is that the election manifesto focuses on giving relief to the victims rather than it is further very clearly understood there is intangible intelligible differentiate between criminalization and non-criminalization marital rape, Your Lordship. The Council seeks permission to move on to the third issue, Lordship. Much obliged to Your Lordship. The third issue reads as whether the marital rape should be criminalized. My lords, the criminal jurisprudence revolves around the intention, knowledge, and consequences of a certain act that is a crime. Hence, the main object of the criminal law is to punish the offenders who does an act with an intention and knowledge. The real test to differentiate crime from a civil is degree that extend to disturbances an act causes the normal balanced peaceful tempo of community, not mere definition crime given in such act the law of the crimes. Rape is defined as sexual intercourse without victim's real consent under section 375 of Emergent Penal Code. However, the exception 2 is mentioned, sexual intercourse being a man and his wife if the wife is not under the age of 15 is not a rape. International law and marital rape. In December 1993, the United Nations High Court Commission of Human Rights published a declaration on elimination of violence against women. This establishes marital rape as a human rights violation. In 1987, UNICEF, United Nations Development Fund for Wealth, reported that 17 states had criminalized marital rape in 2003 and 50 states did so. The countries like Poland, Soviet Union were first to criminalize marital rape. Recent countries criminalized marital rape includes Zimbabwe in 2001, Turkey, Cambodia 2005, Malaysia 2007, Thailand 2007, South Korea. Violation of Article 21, protection of life and personal liberty. Article 15 says that there must be any discrimination. Lordship? Lordship, much obliged, Lordship. The Indian Penal Code is enacted by Macaulay on the grounds by considering both women, men and women, so that
and one shelters without legally married, but the married couple were another views. The way she filed this number of writ petitions before the Honorable Court of Appropriate Remedy, the Bantu Mukti case, the court endorsed the statement of law laid by the Bhagavati. Article 32 does not merely confer power on the court to issue the directions, order the writ of the enforcement, the fundamental rights, but it lays a constitutional obligation on the court to protect the fundamental rights of the people and for the rights of the people and for the innovations, methods, and strategies, particularly for informing the fundamental rights of the poor and disadvantaged who are denied their human fundamental rights and whom freedom and liberty have no meaning. Lord, shall I start my argument, ma'am? Whether the criminalizations of martial rape is constitutionally valid, Article 13 1 says that all laws is forced in the in for as they are inconstitutional with the provisions of this part shall to the extent in such unconstitutional be and the law protections of the law within the territory of the India. Hence, it is due to the state through laws give equal protections to all without the discriminancy. When imposed penal law against the offense of rape, there could be no discriminations between married or unmarried women. IPC defends the offense of rape under section 375. The defense of rape has many integrated constitutions that offense, of which will and constitutes the victim woman are the main factor to decide whether the offense of rape was committed or not against the victim, and also to decide whether does not the offense have to be convicted or not. In the planet, women are also women when they get married or not married. Unmarried women or of any reason, including marriage, cannot waive the right provided in Part 3 Fundamental Rights in the Constitutions. Marriage never be a license to a human for an husband to involve any sexual acts as described in Section 375 of IPC with his own wife against her will or conflict. If a man could be criminalized for an offense of rape committed against any woman is described 375 committed against of his wife. Exemptions to given the provisions of international both the individual upon his own
not penalized in India. The spouse in the marriage are treated as an equal partner, and the husband cannot claim any superior rights over your wife either with respect to her body or with a reference to the individual status. Treated wife's body as something owning to the husband and committing a sexual act against her will and nothing to be a marital rape. The trial court also ruled in this ruling that the respondent was guilty of cruelty under section 498A of Imada Penal Code of 1860 and sentenced him for 2 years of prison and a fine of 10,000. Additionally, he was found guilty of violation of section 354A of the Imada Penal Code of 1860. And Abhinaya contended that she was not giving the fair trial. It was contended by her. The Karthik was convicted by the trial court for the offence mentioned under 354A of IPC of sexual harassment. Then why he is not been convicted for the offence of rape under under section 375 of the Mother Penal Code? And the reason for the criminalizing of the marital rape. Sexual consent without the consent of the woman is a rape, but in the case of the married woman, it is already considered to be a implied consent including the sexual intercourse. Exception 2 of the section 375 of the Indian Penal Code oppose the article 14 of the Indian Constitution. This totally contradict what is given in the exception 2 of section 375 of IPC. Through the marital rape may falls under the cruelty section 498A of IPC stated above cruelties. This is violate this respect of the marital rape and offence already under the protection of women from the Domestic Violence Act of 2005. It does not act much of help to the criminalizing of marital rape. Exception 2 also violates a woman's right to autonomy with under Article 21 of the Constitutions. Article 21, right to life and personal liberty, Your Lordship. If the Lordship permits, the Council move on to the prayer.
It has to be considered as constitutionally valid. Highly objective.
To the applicable the offence committed by the Sugil. The implementation of the election manifesto by the government, the repeal of marital rape exception will not given in the safety and right of the woman is constitutionally valid under section 15 class 3 and 21. The rape is a rape whether it's committed by a husband.
The relationship should be considered as marriage and marital rape should not be brought under the purview of the relationship. Hold, the implementation of election manifesto by the government is constitutionally valid. Hold, the criminalization of marital rape is constitutionally valid. And pass any other order that it is in the interest of justice, equality, and good consent. The Constitution of it is. A highly obvious term. Thank you.
Long meetings were on the bench. This is something appealing on behalf of the respondent who came out of that. Council seeks permission to address the next collectively at the lordship. Much obliged. My lordship. Council seeks permission to address council seeks permission to state the brief proposal of the facts of the case. Much obliged. In the present case, your lordship, Union of Nimata is a party that is government and the state of Kuwait is a southern state in Nimata, which has a highly rich background for languages. In this fact, your lordship, basically they have seen three sequences of events. The first sequence of events is about Abhinaya and Bharat. They are the sequence of events that the married couple living together in a family law. And as a consequence, the family law are accepting Abhinaya to fulfill her marital home responsibilities. And Abhinaya failed to do this. And because of that, the difference of perception arose. And because of this push and pull between the husband and wife, the wife Abhinaya took a break from the conjugal relationship and she went to her parents' home for seeking peace and refuge. In the course of time, Karthik tried to approach Abhinaya and when he reached her home, they had he was intoxicated and the argument moved on and they had a rejection. Constantly addressed issue number 1 and issue number 2. Regarding the second issue, first issue, the second issue. The second issue will be upon the same issue, the repeal of NRE case. It was announced, the repeal of NRE was announced in the regional party selection manifesto in the state of Odisha. And with the high female voters, they formed a government. But the association for agreement in NGO filed a petition against the move of the cabinet resolution bill, and the decision was in the favor of the petition because provided in the high court. And the state of Odisha is supposed to be for the implementation of the said manifesto. Moving on to the second issue, that is the first story. Here it is about Brianna and Julie, the ITN. Basically, these couples were the followers of the radical school of thought. And they were in a conjugal relationship because organizing their marriage for more than 1 year. And moreover, they were cohabiting in the same apartment, in a posh apartment in a place called Manala, the city of the capital of the city of Kuwait. And also they were engaged in the social life. After the event of Sunil losing his job, we have found a friend in the office.
Your lordship, there was a girl baby for the complaint and an accused, your lordship. There were a little bit, they were in a quarrel heated to after 4 years of their relationship, your lordship. This case was in first Rajasthan, your lordship. The complainant states that the accused was in a hitting quarrel, like your lordship. So the Rajasthan High Court states that the bail cannot be given to the accused, your lordship. But in the Supreme Court, the accused move on to the Supreme Court in the bench of Justice Hemant Gupta and Vikram Nath, judge ordered that the bail can be given to the accused because they noted that it was admitted by the complainant that she was in relationship with the Para number. The very next day, Abhinya, in the state of shock, narrated her ordeal to her family, who immediately went to the nearest police station and lodged a complaint against Karthik for committing rape with. I said Abhinya and their relatives. Relationship? The person who is affecting from the relationship. Yes, Lordship, the
So this did a frequent fight between Abhinay and Karthik. There was an occasion where there was a get together between the families, neighbors, and the relatives. You know that time, even Karthik and Abhinay has took place. This made Abhinay and we wanted to leave to her parents' house for a while. And she left her marital home. When Abhinay left, Karthik wanted to contact Abhinay, contact Abhinay's text and call, but Abhinay did not answer any of them. And Karthik wanted to know why she was not interested to meet Karthik. And Abhinay said that she was so alone and she did not she wanted some more time to think about the relationship. Whereas on the same evening, Karthik got intoxicated and he lost his control and forced himself to engage in sexual activity with Abhinaya. First, Abhinaya fought, but then she gave the consent to Karthik itself. Then later, the next day itself, Abhinaya went and lodged a complaint in Mayawar police station under section 375, 490B and 354A of IPC. And it soon got a media light where Abhinaya's case was held in Ariyapatti trial court, where in that court it was held that Karthik was
also in the petitioner has not mentioned it, even though in the favor of petitioner, Indra Sharma versus Union of India. Even in there is no law, sir, Your Lordship. There is no presently. There is no law in. There is no law in favor of the domestic relationship at present. Therefore, we are without any. For a requirement of a marriage, there is a case law, Your Lordship. Also, it has been provided in the Privy Council period itself, Your Lordship. The same has been provided in page number 10 in memorial for respondent, Your Lordship. In the last paragraph, page number 10. In Gobler versus Havangana, it has been provided that they have to be living together as a spouse. Only then the marriage will be considered, Your Lordship. Council seeks permission to, yes, indeed, Your Lordship. No, Your Lordship, but it has been referred also in Indian cases, Your Lordship. And it is not, Your Lordship, but it is a persuasive authority. It is up to the honorable bench to decide upon the same. Your Lordship, the same has also been recognized, Your Lordship. Actually, in the Indian case law, it has been provided and it has been provided in the compendium for memorial of respondent itself, Your Lordship. Council seeks permission of 1 minute. I'll inform the page number, Your Lordship. Okay, much obliged, Your Lordship. Your Lordship, with that being said, in the present case, there is no agreement for marriage between the couple even. There was no open consent saying that the Sunil will be marrying Kriya. But there is only a living relationship, only the want for the physical relationship, Your Lordship. And also, they entered into conjugal relation without solemnizing the marriage, as a fact stands clear in front of us. And this exhibits a mere requirement of physical relationship rather than the concept of consortium omnis vitae, which means there has to be a physical which means there has to be a social obligation as a family, Your Lordship. It has been decided in the case law of Privy Council as stated earlier. And this act shows that the couple were more of in a relationship of a walk-in, walk-out relationship rather than of a marriage. And therefore, Your Lordship, the stance of the petition.
The argument said in court, it proved that Susan was not found of guilt of rape. Since the state was unable to establish it in Florida, the trial court also held that the respondent was guilty under section 498A and 354A of the Northern Penal Code and sentenced to death. Abhinaya lodged an appeal before the High Court of Manavar to convict Karthik for the offence of rape. On High Court's dismissal of the appeal on the ground that the law of Union of India did not recognize marital rape.
She filed a writ petition before the Supreme Court of Nevada. Writ petition number 1234 of 2021. My lord, as this case received media attention, the state of Province was scheduled to hold its subsequent assembly election. Democratic Movement of Province, a regional party, was announcing the repeal of marital rape exception in section 375 of Emergent Penal Code in the election manifesto. The party received a majority in the election and formed the government. The government passed a cabinet resolution to introduce the bill to remove a marital rape exception in the Emergent Penal Code and the prayer of women association. The High Court stayed the government decision of the removal of marital rape exception. As it involves substantial question of law, the state of Province approached the Supreme Court to implement the promise of election manifesto. Then Priya and Sunil enter into a conjugal relationship without solemnizing the marriage. Sunil, due to pandemic reasons, lost his job in 2020 and started developing infidelity complex. Priya, Priya became close to her in Praveen, which made Sunil suspicious of their relationship. They started having bitter quarrels and later Sunil started hitting her. He then forced himself upon her, causing injuries in her body. Priya filed a complaint of marital rape, but the police refused to file a complaint as marital rape, as there is no evidence of marriage between them. Priya filed a writ petition under Article 32, stating that her complaint must be taken as marital rape. All these petitions have been filed involved same question of law and hence listed collectively. The council asked for the permission to argue on the issue. Much obvious, Your Lordship. The first
That it will become an easy tool for women to harass their husbands also, Your Lordship. Sexual harassment is not only for women, it is also for men, Your Lordship. If marital rape exception has been implemented by election manifesto, then it will be an danger risk for society of men, Your Lordship. We too and we men should be balanced equally, Your Lordship. Since female voters are higher, so the political party have targeted them and they have given an election manifesto, and that cannot be implemented directly, Your Lordship. Since it is in
State of province only, they are not enacting any law. They are simply gathering the truth, they are bringing a resolution and approval of the resolution. So it's only a cabinet resolution. So your interview before the High Court is absolutely premature. How do you file such kind of recommendation at the stage of bills?
much obliged, Your Lordship. Your Lordship, here, after the bill is passed, it might become an act, Your Lordship. So at the initial stage itself, the men is approaching the court to render justice for them, Your Lordship.
Is there any precedent with respect to challenging of the bill or challenging of cabinet resolution? Do you have any clarity?
No, Your Lordship. Apologies, Your Lordship. The judicial system in India is competent enough to identify false marital rape accusation and complaints. The person who files such complaint must be answerable according to law. Just because some woman can possibly file false complaint. So, implementation.
Women who is not less than 15 years not less than 15 years of age shall not come under rape. Only the women who is below 15 after a marriage without her consent, if sexual intercourse made by the men, will only comes under a rape. So for this, consent is also much obvious to answer your question. Consent is also important, but in the case how the consent is given, either willful consent or a threatened or forceful consent. If it makes to a threatened or forceful incident, by the surroundings or circumstances, if the evidence provided that they had cured the sound, they had cured the scenery. If the surroundings also stated that the consent was only given by the forceful and threatened by the men, it will come under marital rape. here in the case of Vinaya, she initially fought against her husband, but the consent was laterally given to him. But the situation speaks, but the surroundings speak, the consent was not cured by the surroundings. Even it shall be willful consent or not willful consent. It shall only be known by the Abhinaya and Kartik only. So without the proper evidence, Kartik will not be punished for this sexual marital behavior. And for this complaint of a petition, she shall find a petition on Kartik for 498A of guilty of cruelty. For this section, he shall be punished for 2 years of imprisonment and fine of 10,000 rupees. And he shall also be punished by the section 354A of IPC of sexual harassment for 10,000 for 25,000 of fine and imprisonment for 2 years. So he is not committed a marital rape, so he will not be punished under section 375 of IPC. And if once it was wrongly judged as marital rape, he will be imprisoned for not less than 10 years. So, Council seek permission for the prayer. Much appreciated. For the issues, facts, and the arguments mentioned here, the council seeks the judges to give the judgment on the favor of a respondent or on the basis of justice equality. Thank you. That's all.
My friend counsel has argued for that. It is not in the valid marriage. The long period of the long period of the duration of the long period of the living life is considered as a marriage. It's also valid. And then why the harassment of the offences will not be considered under this provision.
So I'm here to answer my co-counsel's answer. For permission. So here, sexual harassment stated in section 354A states me without the consent of women by sexual intercourse made by the men only, it will come under sexual harassment. For here, Abhinaya gives the consent, even it is willful or not willful consent. First, in the case of Pani Rajan's case, once consent given, not no ever it is willful or not willful. If once consent given, then he should fulfill their promise. So it's not. So it shall can comes under sexual harassment and not.
Enacts that nothing in Article 15 shall prevent the state from making any special provision for particularly women and children, your lordship. Then how the land respondent likely saying that they may contest it is as an inequality, your lordship. That's our your lordship.
Your Lordship, in Article 15, Class 1, it has been stated that for welfare of women and children, the state can enact any laws, Your Lordship. 15 Class, apologies, Your Lordship. 15 Class 3, it states like welfare for welfare of women and children, they can enact any laws, Your Lordship. So here, criminal law cannot be brought under the welfare conditions, Your Lordship. And if it is so happen, it will entirely discriminate the society of men. So it cannot be, they cannot implement marital rape exception, Your Lordship. Your Lordship, in that case, both have been in a relationship for so many years, Your Lordship. So it has been considered in that state. But here, they cannot, we cannot consider that under the purview of this, Your Lordship. Much obliged, Your Lordship.
Force of other indicating absence of willingness or consent. This shows the obvious intent of legislation is using the obvious expression sexual intercourse and acts without referring the presence or absence of the marital rape, sphere of allegation of the rape. Your Lordship, moreover, it shows that the sphere of rape, according to the legislature, should never disorder a marital relationship between man and his wife. The legislature holds so because the marriage is neither a playground nor a traditional area. The entire bedrock of society rests on bedrock and family. Moreover, the council seeks to point out that the court is hearing divorce petition. Even by mutual consent is our legal system, not entirely grant divorce right nowadays. Even the both parties appears to be inconsiderate in odds to judge boundaries by court, to converse and interact with bonding couples, and to make every possible effort to save rather than save mutual bond. Your Lordship, a man is a sacred unit, legally permission of two healthy bodies of opposite sex. It has to be mental, psychological, and physical. So where two souls connected, there's a new soul comes to be existence. That is how the life goes on this planet. However, man is unconsciously does not entail his husband to wear his wife into the ship. If she is not interested or inclined. Your Lordship, the impertinent exception does not. Your Lordship.
What is your contention?
Sir, marriage is a social instrument. So, confer legitimated to sexual activity between a man and woman, a child born at wedlock. The state of being married, therefore, is a legitimate. This exception of sex of the husband with his wife, therefore, the legitimate expectation healthy sexual relationship. Being integrated with the marital bond. Unjustified denial of a sexual access by either spouse of the couple is not therefore satisfied or even condemned by law. It may not invade criminal action, it nonetheless entails the spouse, to whom the sexual access has been unjustified denied, to seek their separation by the way of law. Secondly, the exception does not violate Article 14 of
I would like to point certain statements which is made by. Yes, ma'am. Yes, Your Lordship. It is not marriage. This is very thing, and the reason is can you just read it?
required to keep in mind distinction between the object how to be achieved by the statutory provisions and the relation for the object. Concerning the
Provision in IPC 376 ABCD, which also specifies certain. When the topic comes to marriage, marriage itself is a and the
when one person, man and woman being married, they there should be no discrimination between husband and wife. No discrimination should be made. The legislation escaped from the administratively, it is to preserve the marital institution. They were living together and they were doing equal activities, both of them. So their neighbors as well as all of them will be considered as a marriage.
Against the discriminatory treatment. It doesn't, however, operate against others. So here in this comparing the Dilip Pandey versus state of Chandigarh, by comparing this case with this article, there is no any discrimination between the husband and wife. They were a married couple, and also the sexual intercourse between the husband and wife will not actually consider as a rape. So there is no discrimination, and also here the women are not. Here the woman is not being in the discrimination state. So the article violation of article is doesn't take place, and also Article 15 says that prohibition of discrimination on the base of the sex, caste, and religion. So in this case also, on the discrimination doesn't happen here for the women. So there is no violation of a fundamental right as of Article 14 and 15, ladyship.
Who is in judicial separation? Is a married man. That is the thing that is to speak. Now you are saying that a rape of a wife is not
Exactly.
wife in judicial separation and otherwise. What is the classification? Whether it is reasonable.
Wife in judicial separation and
Wife in judicial separation and wife living with his husband. You are considering one as a rape and another as not a marriage.
indeed, your ladyship. Here, under Section 375 IPC, exception says that simply the sexual intercourse between the husband and wife will not be considered.
This Abhinaya is already separated from his husband. Okay, she is not willing to live with her. But the husband is not willing to wife or they will. Why cannot this person can be charged under these and this is
Indeed, your ladyship. Here, the facts here in this fact, the husband Karthik was being intoxicated.
both the memorials I have not found the 360. Okay. That 360 already punishes marital rape to some cases. Why cannot we get why the Union of India and the other states give protection to women for all the married couples? Whether it is reasonable, the wife living with his husband and the separated wife, whether it is reasonable.
Indeed, your ladyship. Your ladyship, here the thirdly, the removal of MRE affect the institutions of marriage. Hereby, in the Dilip Pandey versus the state of Chandigarh state that it is not actually considered as a sexual intercourse. And also, here in this case states that the country like the Imardan, which is renowned for its high heritage of family institution. So here in the country, in the Imardan Penal Code, does not actually promote, and the Imardan actually does not promote the removal of MRE exception in the Imardan Penal Code. So here, your ladyship, the criminalization of marital rape is not constitutionally valid because in the country like the Imardan, firstly, it is itself reasons for the high heritage of family system, and also the government on a multiple times said that it will destabilize the institutions of marriage. Your ladyship, the council seek permission to submit the comparative regarding to the issue.